So we're going to use some examples here today in Southern California, at least on my part, okay? That you heard me mention a nice lady who's been in the same house for 37 years and her home's worth over $1 million. And people in Nebraska might be thinking right now, oh my gosh, what a mansion. No, that's a 3-bedroom, 2-bath house with
Right.
2,100 square feet. I mean, that's California. So the idea of an estate large enough to worry about getting a living trust now could be a very basic question. Like, do you have a home in New York State? Do you have a home in a nice suburb in Florida or Chicago? But do you have a home in California? If the answer is yes, that you have real property, then a living trust might be a very appropriate thing to have, because the living trust avoids probate. So
Right,
the probate
right.
process is the big part that we're trying to avoid. And a living trust really helps to avoid probate in a big way.
So,
Now,
so the will and the trust go hand in hand typically. And the will, I've heard you talk about
yes,
before, is a pour over will that connects with the trust.
absolutely. The idea of a pour over will, just saying, if Paul, for example, created a will and a trust, and Paul missed some of his belongings being written out in his will or his instructions, they are intended to pour over into his living trust so that we keep everything out of probate. Now, the piece that I wanted to highlight that's a little extra today that we've not touched on in depth with living trust is this idea of testamentary provisions. It's
Yeah,
a
what
big
is that
word,
about?
but testamentary means at your death. It's like your deathbed wishes. You know, your estate plan can have testamentary provisions. For example, here's one that we're doing right now for one of our clients in the firm, that she wants her life insurance proceeds to go into her living trust, her estate plan. And then at her death, though, they go into her estate plan, and a special trust is created out of her living trust for the benefit of her grandchildren.
Oh,
A
okay.
testamentary trust will be created for the benefit of her grandchildren to help pay for college and to help with a first home purchase and things that will go on well beyond her, that will also be, this is the key, asset protected for those grandchildren and great grandchildren.
Nice. Very nice.
Yes, it's something that can be built in where she doesn't have to make up a trust today. She can build the life insurance into her plan that will fund a testamentary trust that will come into being when she leaves, right?
Right.
There's another one that we're doing actually that is for a really nice lady in Florida, that she wants to make sure that assets, she has some pretty nice assets, some of her home and some rental properties and stuff. She wants to make sure those assets go to her favorite daughter, but not to her least favorite son-in-law, her favorite daughter's husband.
Okay.
So she has a testamentary provision built into her estate plan that a trust will be created for the benefit of her daughter and only for her daughter and her children, not for daughter's husband or who might be an ex-husband someday.
Got it.
Can you see what I mean?
Yeah, yeah. No, it's interesting because we have that discussion a lot. I know you have it, our attorneys have it, of not just giving assets outright to your kids, you know, but give them in an asset protected way to avoid, you know, those hard-earned assets over time being hit by potential creditors of your kids. It could be, you know, an ex-spouse, a tax issue. You know, people don't think about this, but there are ways to make that a fluid transition.
Yeah, absolutely. One more in that living trust piece, right? Because these are the documents you've got to have. That will for sure, a living trust, but there's a provision that you could also consider inside the living trust conversation, and that's charitable giving, where a great story just recently hit the news. It was actually last year, but I always love this kind of a story where a man who attributes most of his success in life to being accepted into the engineering program at a university here in California. It really changed the course of his life. He became extremely successful, started a very successful business. And at the end of his life, what he wanted to have happen was that his car collection worth $12 to $15 million in classic and collectible cars, he built into his living trust a testamentary provision to donate his car collection to the university that he attributes so much of his success to. That is super cool.
Yeah,
right?
very cool.
Love that.
Yeah.
Love
and,
that.
Yeah, and I know you're a car guy, and we could, if we start talking Porsches right now, we'd get derailed here. So
yeah, I know, D. Don't want to talk Porsches.
No.
But,
all right, so we got that down. That's great. What is the next tool we want to jump into?
Okay, so we've touched on this. We won't go too deep into this, but it is a healthcare proxy. It's really the power of attorney for healthcare, making sure that you've got that in place. There are still in the news of actually well-known famous people who end up in the hospital, and there are disputes over medical care because they didn't have their power of attorney, their healthcare proxies done. So that is a huge one. The one that I want to highlight today, though, that folks who've heard you and I talk before, you've heard these things, but I want to share a story about the financial power of attorney. So that's the next document. It's that financial power of attorney. This actually just happened with a client of mine and one of the attorneys at the firm, that sadly, mom passed away not long after her and her husband's estate plan was signed. Just got it in the nick of time. The living trust and the will and everything was done. Mom passed away, and then to add just difficult to difficult, dad had a stroke a month later. It was a really tough time, and he ends up now in the hospital. Well, the daughter who was assigned as their trustee, their favorite daughter, discovered that mom and dad had not included a piece of land, a valuable piece of property here in California. They did not mention it to me or our attorney. It was just kind of hiding in a drawer. She discovered this piece of land was not in the living trust. But with the power of attorney, remember, dad is still in the hospital. Right. Now the power of attorney for financial matters is in play, and their daughter was able to work with the notary to get the transfer deed done on behalf of dad, so that when dad did subsequently pass away, that piece of land was titled properly in the living trust, no probate.
Oh, interesting. I mean, it's a sad story for the family.
It's very sad, but it was just under the wire that if the daughter did not have that power of attorney,
what would have happened?
She would have had to open probate on a $200,000 piece of land in a county that would take probably 18 months minimum to settle the probate on that piece of land.
Unbelievable.
It would have probably cost her $15,000 in fees and lawyer fees.
Yeah.
But instead, thankfully, our firm scans all of these important documents, and we were able to send those documents directly to the daughter and the escrow team and confirm that it's all set.
Yeah. And they do ask for the documents. I mean, you can't just say, "Oh, I can speak for my dad." I mean, they're going to ask for them.
Absolutely. They're going to see them, and they want to see the recording dates, and they want to see the notary signature dates and all of that. So power of attorney for financial matters, we hope we never have to use it. But boy, when it comes up, and this is seriously just happened yesterday, Paul, and I have to say I was so relieved that we as a firm together were able to get that done in a very short time frame before everything happened.
Okay.
So
all right.
It was good. The fifth one.
Cool. Yeah.
The fifth one, and this is one that people think guardianship provisions oh, I don't have any minor children, I don't have any kids, so I don't have to worry about that. Well, guardianship provisions may not be specifically just for minor children. What if you have a special needs son or daughter, someone that has challenges or a disability that might cause them to be on government benefits? They might receive Social Security disability benefits, for example. What if there are children who have the potential for creditor attack?
Right.
What if you've got a child that is in a
Real
situation
estate,
that real estate
yeah.
or construction businesses where you worry about your son or daughter receiving an inheritance? Well, you can establish guardianship provisions in the form of a trust protector. So an outside trustee, someone who manages a trust on behalf of that child, as essentially a guardianship provision built into your estate plan to make sure that that child would receive their inheritance in a protected fashion.
Yeah, well, it's interesting because where that can come up is that, you know, let's say, you know, you've got kids and your kids have all their stuff going on. If one of your kids, and this was a scenario that we encountered, but there was a judgment against one of the children that was, you know, that had been there. And it was related to some tax issue or something. And the IRS is a super creditor. I mean, they can just go in and grab stuff. If
yeah, they take it right out of your checking account.
Yeah. But the point is that there was a liability out there, you know, and those liabilities in certain cases, they don't go away. You know, they're sitting on a shelf and a creditor will pull it off the shelf the minute they start sniffing you got assets. Right. And so in this scenario, there was an asset protection trust set up as part of the estate plan, and the assets went in for the child into this protected entity, which the creditor, you know, couldn't even sniff out. So things like that, you just got to have your mind going all the time, because the minute you miss something, you could just be nailed to the wall.
Absolutely. And Paul, back to your original premise with today's episode, that it's not specifically a tool of the rich.
Right.
These are not extremely expensive things to do. It's just most people do not prioritize getting their estate plan done at the level that you and I might suggest that they prioritize it. Right. They're too busy planning, whether they're going to watch the entire season of Yellowstone on one day, or
I wouldn't blame them.
Right. And yet, if you look at it, it's just a relatively simple process. It is that initial assessment discussion with myself and perhaps one of our attorneys, and the process is not overly complicated, and it is not overly expensive to actually make it happen and get it done. Right. So we're always standing by, ready to assist in any way that we can.
Yeah, and with that, I'll mention I put up in the chat there for everyone who's on. We've got a great crowd here. I recognize some of the names. It's great to see people here. But if you can sign up for your initial intake call there with that link.
Oh, excellent.
Yeah, and there's a worksheet there too, that when you fill that out, it's always helpful to understand what do you own, so that the assessment can really be one-on-one, and we can be prepared to give you insight and invaluable input. And so it's a short worksheet, but fill that out. Probably take you 5 or 10 minutes if you want to do it. Craig, always great to have you on the show here. I want to thank everybody for tuning in. Remember, every Thursday?
Every Thursday.
Yeah, California.
It's Thursday all day today, Paul.
We got so many live shows going on. It's hard to keep track, but this is a great one. And thank you for being here. We'll see you next time, Craig. Thanks so much.
Take care.
All right.